Hi, I'm Randy Brotherhood, and I'm a shareholder in the Milwaukee law firm of Meissner Tierney Fisher Nichols. Among my areas of practice is intellectual property law, and this is the second in a series of videos I'm doing on the law of trademarks and their relevance to businesses. In this video, I'd like to discuss how a business, once it selects a trademark, should go about protecting its rights in its mark, including the benefits of federal trademark registration and how to obtain registration of the mark. Once a mark is selected, the key next steps consist of, first, searching the trademark and clearing it for use, and second, applying for federal registration of the mark with the U.S. Patent and Trademark Office. As to this first step, a trademark search is an absolutely crucial yet sometimes overlooked aspect of trademark protection. The purpose of a trademark search is to identify potential risks by determining whether there are any trademarks already in existence which could force the owner of the new mark to stop using it or otherwise limit the new owner's ability to use it in connection with its particular product or service. Having to cease using a trademark after it's been put into use can be catastrophic if a business has expended substantial resources in implementing the mark and developing public awareness of it in the marketplace. Most trademark attorneys use a two-step approach to trademark searching. The first step is what is referred to as a knockout trademark search. A knockout search is a quick search of publicly available sources such as the PTO's database of registered trademarks, as well as the internet. The purpose of a knockout search is to identify right out of the chute any obvious and easily identifiable obstacles that might prevent the trademark owner from further considering its prospective mark. Clients often want to base their decision on the results of the knockout search alone, but there are serious limitations on this type of search. Knockout searches are by their nature preliminary and not comprehensive, and they usually only detect the easy and obvious low-hanging fruit. So it is important to then obtain a comprehensive, methodical search of all U.S. trademark sources, which is the safest and best way to assess the entire universe of risks that exist in moving forward with the selected mark. In addition to providing a more detailed and comprehensive review of PTO filings, the comprehensive search includes a methodical drilling down into various proprietary business and industry databases and directories, state trademark registrations, and domain name registrations. Trademark searches are usually done by a specialized search firm, and trademark lawyers like me commission them to do these searches. The search firm delivers a thick written report containing references and detailed information about all trademarks that are either identical to the client's mark or which, in the search firm's judgment, could be considered confusingly similar to the client's mark. The trademark lawyer then reviews and evaluates the information in the search report in relation to the legal standards for determining whether there is a likelihood of confusion in the marketplace between the client's mark and any of the other marks noted in the report. The lawyer will then provide the client with advice regarding whether the mark is clear for use and registration. While there are limitations on the effectiveness of both knockout and comprehensive trademark searches, they are very important and a necessary part of the trademark process, and they usually will save a business a lot of time, money, and stress if it turns out there's another mark out there already in use that it could expose the business to a trademark infringement action. So once a trademark makes its way through the trademark search phase, the primary way to then proceed to protect rights in a trademark is to register the mark at the federal level with the U.S. Patent and Trademark Office. However, it should be noted that it is not necessary to obtain either a state or a federal registration in order to be able to protect a mark, because legal rights in a trademark are based upon use, not registration of the mark. Although unregistered marks receive some of the protection under common law and under the federal trademark statute known as the Lanham Act, trademarks in almost all cases should be further protected through registration at the federal level. Federal trademark registration provides significant substantive and procedural rights to a trademark owner. An application is filed electronically through the PTO's web portal, and it must indicate one or more of 40+ available classes of goods or services in which the mark is used, and contain a description of the specific goods and services within that class. Federal trademark applications are carefully evaluated by trademark lawyers at the PTO. Approval is not a slam dunk, and if the examining attorney at the PTO raises legal objections, the application process can take a good number of months and even more than a year. Federal registration can be on one of two registers maintained by the PTO, the principal register and the supplemental register. For purposes of our discussion, I'm going to focus only on the principal register, which is where most strong trademarks, that is, those that aren't merely descriptive of their goods and services, are registered and which provides the greatest degree of protection. One of the primary benefits of federal registration is that it acts as a bar to the registration of another confusingly similar mark. If someone else tries to register a mark that the PTO considers to be confusingly similar to yours under prevailing legal standards, the PTO will prohibit registration of that mark. But there are other benefits, including the right to use that little R in the circle registered trademark symbol that you often see, which provides notice to the world of your registration and that you intend to assert your legal rights in your trademark. Additionally, there are procedural advantages, including the right to file a trademark infringement lawsuit in federal court and to obtain monetary remedies, including in some cases treble damages and attorney's fees. Registration also entitles the registrant to something called nationwide priority, based on the filing date of the trademark owner's registration application, and it also allows the registration to become incontestable after 5 years of registration, which then creates conclusive evidence of the owner's exclusive rights to use the mark, subject to certain statutory defenses. I'll be discussing other aspects of trademark law, including how to use and not use a trademark, and when and how a business should enforce its trademark in future videos. In the meantime, our firm has extensive experience in handling trademark matters for businesses, so please feel free to call us if you have any questions. Thanks very much for watching.